Commissioner of Gift Tax and Agulam versus Abdul Karim Muhammad, read by LRS. Introduction. This appeal by special leave is against the decision of High Court of Kerala in Income Tax Reference Number 101 of 1974, and it raises an important issue concerning the requirement of a gift made in contemplation of death within the meaning of Section 5111 of Gift Tax Act 1958. Facts. The reference was made under Section 26(1) of the Gift Tax Act 1958 by the Income Tax Appellant Tribunal Council Bench. The tribunal referred to the High Court two questions for its opinion, out of which we are concerned only with the first question, which reads, whether on the fact and the circumstances of the case, the tribunal was right in holding that the gift of movables valued at Rs. 67,578 is not a gift made in contemplation of death within the meaning of Section 5111 of the Gift Tax Act 1958. The facts of the case as found by the tribunal are simple and not unusual. The document was executed on April 24, 1964, and at the time of execution, the donor was seriously ill. There is ample evidence to show that he was seriously ill at the time when he made the gift. In an affidavit filed by him before the gift tax officer on August 3, 1969, the sub-registrar has affirmed that at the time of execution of the document, the settler was in sick bed and was unable to move out of the same. The gift tax officer appealed to the tribunal against the decision of the appellant assistant commissioner. The tribunal has affirmed the finding of the appellant assistant commissioner that the donor at the time of gift was ill and expected to die shortly of his illness. The tribunal, however, did not agree with the exemption allowed to the SSC. The High Court has answered the question in negative and in favor of the SSC. Issue. The legality of the view expressed by the High Court is under challenge in this appeal. Section 191 of the Indian Succession Act deals with the requirements of gifts made in contemplation of death. Ruling. The view taken by the High Court is correct and it does not call for interference. We accordingly dismiss the appeal with causes. Reasoning. The requirements of a gift in contemplation of death as laid down by the Section 191 of the Indian Succession Act are 1. The gift must be movable property. 2. It must be made in contemplation of death. 3. The donor must be ill and he expects to die shortly of the illness. 4. Possession of the property should be delivered to the donee. 5. The gift does not take place if the donor recovers from the illness or the donee predeceases the donor. The gift was made when the donor was seriously ill and apprehending his death. It is implicit in such circumstances that the donor becomes owner of the gifted property if the donor dies of the illness, and if the donor recovers from the illness, the recovery operates as revocation of the gift. The exemption of gift in contemplation of death is provided under Section 5111 of the Act and not under Section 191 of the Indian Succession Act. Section 191 furnishes only the meaning or requirements of gift in contemplation of death. Mohd is a malady which induces the apprehension of death in the person suffering from it and which eventually results in his death. The only limitation under Mohammedan law is that the disposition is restricted to a third on account of the right of the heirs. On the question, the High Court has not expressed any view and it has directed the tribunal to consider that issue afresh. We therefore refrain from expressing any views on that matter.